Hi here, Tony again from Estate Planning Solutions. This week we're going to cover quite an interesting case which is going to alert you to the fact that all the information we've been talking about in these videos, it can summarise all the issues in one foul swoop. So do yourself a favour and download this court case. Just go to Google and Google the court case Manly versus Manly. It's a famous Queensland case that highlights a number of things, and typically it warns us never ever ever get into the courtroom arena, because once you're in there, there's no control, totally no control. It's all in the hands of the legal people, the court system, and the fees just mount and mount. So in the case of Manly versus Manly, you need to go and read it, and read all the transcription of the case, make up your own mind. In my view, there appears to be some untruths told in this court case, but the bottom line is this will was prepared for free by the Public Trustee. Now, that's fine when people are looking for cheap estate planning, but it's not really fine because a couple of things happen. The Public Trustee does the wills for free so that they can manage the estate after someone passes, and of course they collect a percentage of the estate for their action. In this particular case, a man decides to go to the Public Trustee and get a free will. His wife challenges it, and this is a wife who looked after him the last 3 years of his life as he became ill. And the case is quite fascinating when you read it, because it goes through the situation where she wasn't very comfortable with the way the will was designed. And there's a reason for that, is because whoever put it together at the Public Trustee, we know that they're not a specialist, because that's not what they do. They do the wills, but they're not specialists. And they didn't dig deep enough into the circumstances of the gentleman who wanted the will done. As a result, the wife challenged the will, and she was originally told the will stands. So she went to a higher court to have her appeal heard. The only problem with that is we've now got more legal people involved, more barristers, judges and associated staff. So there's a cost involved. At the end of the day, when all the information was given to the court, a decision was made that no, the will stand as it is. For this lady who looked after her husband for the last 3 years of his life, she doesn't have a house to live in, and she had $186,000 worth of legal fees awarded against her out of a total estate which was under $500,000. Now, I guarantee you, if by some magic we could ask Mr. Manly to come down from heaven and ask him the question, Mr. Manly, did you mean for your wife, when you passed away, to be booted out of a house and to be paying off $186,000 in legal fees? I doubt very much that he would have said yes, considering she'd looked after him the last 3 years of his life. So the case is really, really worth Googling, downloading, print it off, take your time to read it, form your own opinion, but it serves as a warning, a very large warning, that in the whole scheme of things, to pay very little or nothing for a will, you run the risk of ending up in the arena of the courtroom, and the arena of the courtroom means you lose all control. And this poor lady now is a victim of a system that's wrong. And again, I stress, I can't do it on my own. People like yourself who are watching this video need to pass on this information, share these videos so that people get educated on making sure their will and estate planning is done in a correct fashion, so that these people who are armed and ready to mount challenges against families and ex-spouses or widows are stopped in their tracks of doing this. Now it can be done. You can make a will guaranteed to be bulletproof against a challenge. What I mean by that is anyone who's got the right to challenge can challenge, but the way that we set them up at Estate Planning Solutions is that if there is a challenge, it will be snuffed out at the beginning. There'll be no going to court. There'll be just a letter, an exchange of letters between two lawyers, one lawyer who is acting for the person who's the aggrieved or the person who wants to challenge will end up getting a letter from the lawyer of the estate to say there's nothing there, there's nothing to challenge. And that only comes from having it set up properly. So it can be done, and do yourself a favour, download the court case Manly versus Manly and form your own opinion.